Attorney Nneka Jackson. I practice immigration law. I do a lot of removal defense as well as family-based immigration matters with USCIS. I have a PowerPoint that I would like to share with you all regarding immigration law and removal proceedings. So give me 1 second. All right. Is the screen sharing?
Yes, ma'am. Yes.
Okay, perfect. Okay, so understanding immigration removal proceedings. Immigration removal proceedings is when you are issued an NTA by the Department of Homeland Security. You could be issued an NTA for various reasons, but once that notice to appear, which is the NTA, is issued, that begins the process of removal proceedings. This presentation is supposed to give you an in-depth analysis of the immigration removal proceedings, its implications, and
your call has been forwarded to voicemail. The person you're trying to reach is not.
Okay. So types of violations that lead to immigration removal proceedings: criminal offenses, visa overstays, fraudulent applications. This also could include if you've had an asylum interview with USCIS and you weren't found to be credible or had a real claim, they'll refer you to the immigration court. Some people have came through the border to seek asylum, and that's how they ended up in immigration court. So these are just some of the ways that will begin your removal proceedings process. Okay, so the INA, it serves as a primary body of law governing immigration and removal proceedings in the United States. It establishes the grounds for removal, it outlines the procedures for hearings, and it details the rights that individuals have that are involved in removal proceedings. The INA is extremely critical for understanding the legal context of the immigration proceedings and the rights that are afforded to non-citizens. Relevant case law and precedents that are shaping the interpretation and application of the INA are in specific cases. We cite the INA in most of our briefings. The INA is also cited in the notice to appear NTA that DHS uses to initiate removal proceedings. The INA is also used for USCIS proceedings as well. The key players in removal proceedings would be immigration judges, defense attorneys, which is what I do, ICE agents authorities, which would be DHS, trial attorneys, we call them assistant chief counsel, so ACCs. You have legal aid organizations, and then you have judicial review processes. All right, so as I mentioned first, you get the notice to appear. That is how you begin your removal proceeding. I have a sample picture here of what an NTA looks like. And it's right here. This is an old one. So it'll have at the top, notice to appear. It'll state your name, your address, and then it'll state the charges of why you were issued a notice to appear. You're an arriving alien. That means that you came into the border, you had parole, you were paroled into the border, you were admitted to the border. So you'll be considered an arriving alien. For bond purposes, if you are an arriving alien, you would not be eligible for bond with the immigration court. So that's like people who came in through the CBP-1 app. It was required for you to come to the CBP-1 app during the Biden administration in order for you to seek asylum. So those kind of people would not be eligible for bond. Then you have the other box that says you're an alien present in the United States that has not been admitted or paroled. That's when most people come in. If they come through the border, that's when most people come through. Or if you have a visa, you'd be non-admitted or paroled. I mean, excuse me, if you came in through like a travel visa, you'd be an alien admitted, not have been admitted or paroled. Or you have been admitted to the United States, but you are removable for the reasons below. That box is for if you have a green card. And then right there, the next line says, the Department of Homeland Security alleges that you, and then it'll have the charges that you did. So you entered the US March 11, 2023. You came through the southern border in El Paso, Texas. At the time, you were not admitted or parole, and you are a native and citizen of Nigeria. And then at the bottom, it'll let you know whether this notice is being issued after an asylum officer has deemed you non-credible. This NTA is a little older, so it doesn't normally say that anymore, or has a second box, which says Section 235 B1. I apologize. I have to take a quick break. It'll be extremely quick. If you just don't mind giving me 2 minutes.
Go ahead, ma'am. Go ahead.
I apologize. My apologies. Okay, so back to what I was saying. The next part is also very important of an NTA. There's a box at the bottom that says Section 235B1, order was vacated pursuant to, and then there's 2 boxes next to it. This section is very important because if this box is checked, that means that you were at once placed in expedited removal proceedings once you came into the border, or even now they're doing expedited removal proceedings, even if you didn't come through the border, or if you came through the border years ago. That's important because you won't be eligible for bond if you are subject to Section 235B1. So that means that you have expedited order. You were in expedited removal proceedings. They gave you a credible prayer interview. Generally, they found that you were credible, and then they referred you to immigration court by issuing the NTA. So long story short, the NTA starts your proceedings in immigration court, and it just pretty much lets you know why you're in immigration court. And then it also has the date and time of when you should be there and the date that it was filed. And then it'll have the city and state. It'll issue the state court, the immigration court that you're supposed to go to. And then it'll let you know when your master hearing, which is your initial hearing, will be. It is very, very, very important that you attend your master hearing, because if you do not go to your master hearing, they will order you removed. And if they order you removed, you will have to file a motion to reopen. Let's say you had a master hearing schedule, missed your master hearing, you didn't have an attorney appear on your behalf, and they order you removed. If you're out and you get stopped by ICE, they will detain you, and you will be detained until you either get the removal order open, seek bond, or any other kind of relief that is available. So, like I said, it is very important that you go to your initial master hearing. You can go by yourself. If you don't have a lawyer, it's okay to go by yourself. You can just let the court know I'm here to appear. I don't have an attorney. Can we please have these matters continue until I get a chance to hire a lawyer? Most judges will do that for you, but you miss that opportunity if you do not appear. You can file, let's say you don't make your master hearing, you were sick, you got into a car accident, somebody in your immediate family died, or you were arrested. If there's any other important emergency, then just get proof of whatever that emergency is, and you can open with a motion. You can file a motion to reopen and provide proof to the court. Hey, I had a master hearing, but I was hospitalized, or I got into a car accident, or my grandmother died, or whatever the reason is. And you provide evidence of that to the court, and they will generally reopen those proceedings. There are fees. If you were ordered removed because you didn't know you had a hearing, there's no fee for that. However, if you were aware of your hearing and there's evidence that you were aware of your hearing, the fees to reopen that are now $1,045. So it's very important you don't miss it, because you end up spending way more money missing it. Okay, so once the NTA is filed, what happens next? Like I said, you'll have a master hearing. You go to that master hearing. At the master hearing, the judge is going to ask you, how do you want to proceed with the NTA? So your attorney, if you have an attorney, they'll speak on your behalf. They'll admit or deny the charges. They'll let the judge know, Judge, my client is seeking asylum. We already filed the asylum application. My client has an I-130 pending. Their spouse filed for them. They're going to seek adjustment of status with the court. Or my client is a SIJ applicant. They have an I-260 that's approved. We're going to seek adjustment of status with the court. Whatever your relief is, their attorney or yourself, if you're doing it pro se, will let the judge know that. If you do want to file for asylum, this is very important. You must file your asylum application within 1 year of entering the United States. So if you came to the U.S. January 1st, 2025, your asylum application will be due December 31st, 2025. You can try to apply January 1st, 2026, but that's very risky. I would not suggest it. So your asylum application, like I said, is due within a year. If you miss that 1 year deadline, there are exceptions to the rule. Every case is different. So you'd have to speak to an attorney to see whether or not what you could do for your case if you missed your deadline. So at the hearing, the judge will go over what your application is for. Since Trump has come into office, it's very important that when you go to the hearing, you have an application already filed. If you just got an attorney, your attorney will let the court know, hey, I was just hired. I need time to file the application. Can we continue this matter for another master hearing? By then, he'll have an application filed. If you do have an application filed, like let's say you're filing for asylum, it is very important that you fill out every answer on that asylum application and you submit a detailed statement if you can. The government's attorneys have been filing motions to pre-termit, and pretty much a motion to pre-termit is saying that the applicant either did not fully fill out their application, so their application should be deemed abandoned, or they did fill out their application, but they don't have a real application. They're not eligible for asylum because there's no past persecution or there's no future fair, there's no fair future harm. So it's very important that when you do submit your asylum application, you answer every question, you offer sufficient details, and you lay out your claim for asylum, or else the department will file a motion to pre-termit. And if the judge grants your motion to pre-termit, that's it. Your removal case is done. They're going to order you removed. If you do have a master hearing and it's in person, I would suggest you hire an attorney so that they could try to do the hearing online. If you are not aware, at these hearings, DHS attorneys have been asking to have the cases pre-terminated or dismissed. Once the cases are dismissed, ICE is coming in and picking people up. So the best way to avoid being detained by ICE is to appear online, and you can make a motion for WebEx with an attorney. Sometimes judges automatically have online appearances, but sometimes they don't. So you should check your NTA to see whether or not it's in person or online. Another way you could check to see whether your hearing is online is through automated case information. I can submit the link to that online in the chat so that you can see the link to that. I apologize. I will submit the link in the group chat, the link that you can fill out. You put your alien number in, you'll put the state, the country that you're from, and then it'll have online whether or not it's in person or if it is online. If you're still confused about whether it's in person or online, you can also call your immigration court, give them your alien number, and they will let you know whether it's online or in person. So that's also very important, because if your hearing's in person and you appear online and the judge doesn't allow online appearances for clients, they will try to have your case dismissed or order you removed for failing to appear. So I just want to make that known. And then at the end, if you have any questions, please feel free to ask. I'm here to help as much as I can. All right, so you got the NTA. You went to the master hearing. You guys addressed what's the allegations in the NTA. Your attorney let the court know what kind of relief you're filing. You filed your application. Now, at this point, the judge will give you a hearing date. This is called your individual hearing. Before your individual hearing, this is very important. You're going to need to take biometrics. Whatever application you're filing, you need to get your fingerprints. So if you have an attorney, they will submit your applications. They'll get the relief. They'll get the biometrics appointment information. So you won't really have to worry about that. Your attorney will let you know when your biometrics appointment is. If you don't have an attorney and you're doing things pro se, I would suggest you, after you fill out your application and mail it in, they will mail you a notice of when your biometrics appointment is. You must get fingerprinted. If you get to your individual hearing and you are not fingerprinted, the judge may order you removed for failing to prosecute your case. They may deem your application abandoned. So it is very important. If you've sent multiple requests to USCIS and they still haven't scheduled an appointment, you need to provide that evidence to the court and say, hey, they've never sent me a biometrics appointment. I reached out to them multiple times. I have not gotten an appointment date. I'm trying to get it. What can we do? If you don't get your prints by the time of your hearing and you've shown to the court that you've tried multiple times, what most courts will do is they'll let you go through the hearing and then they won't issue a decision until you get printed. You also will have a call-up date. That's usually 30 days before your hearing, 15 to 30 days, depending on the judge. Before that call-up date, you need to submit all of your evidence. That's a completed application. That's your statement. That's country conditions, news articles. This is for asylum, news articles. Any evidence you may have if you've been persecuted, any photos, medical records, statements from family and friends, all of that will be due before. If you have a different case where, let's say you applied for a green card, your spouse or your child or whoever applied for an I-130 on your behalf and it was approved and you're just getting a green card to the court, all you would need to submit to the court is your green card application, your medical evaluation, fingerprints, and then any additional evidence that you want to submit. Maybe you want to submit your photographs showing that you and your wife are in a good relationship, birth certificates, things like that, your identity documents. If you're doing cancellation of removal, that means that you've been in the U.S. for over 10 years, you have good moral character, you have evidence of that 10 years, no criminal crime, and you have, if you were ordered removed, your U.S. citizen child, spouse, green card child, spouse, parent, whatever, qualifying relative, was suffer severe harm if you were removed, you submit all of that evidence. So you have to submit that before the call-up date. You are allowed to have witnesses. If you don't have witnesses, it's fine. As long as a witness can submit a statement on your behalf, you can still get asylum or cancellation of removal, whatever relief you're seeking. It's better to have a witness appear, but if they can't, the courts will understand just a statement from them saying that you're eligible for whatever relief you're seeking with the court. At that point too, at your hearing, when you get there, the judge will take a sworn statement from you. They're gonna say, you're telling me that everything in this application that you filled out to the court is true and correct to the best of your knowledge. If you submit any
No, that's how we.
Oh, I think somebody's talking. Okay, thank you. I didn't know how to read them. Yes. At the hearing, after you take your sworn statement, your attorney generally will ask you some questions about your application. So, perfect example, if you're filing for asylum, your attorney's gonna ask, why'd you leave your country? What happened to you? Who attacked you? How many times were you attacked? Why did they attack you? Oh, they attacked you because you are a Christian and from a Muslim village. Oh, they attacked you because, I don't know if they do this in Nigeria, but in Guinea and other countries, they have female genital mutilation, FGM. Oh, they tried to remove a certain part of your body without your consent. Oh, your family attacked you because you married somebody from a different tribe. Oh, your tribes are at war, or whatever your asylum claim is, we're gonna ask you questions about that. The judge may ask you some questions as well. Once your attorney is done asking you questions, government's attorney will ask you questions. They're gonna ask you very tough questions. Their job is to make sure that they catch you in a lie. Because if they catch you in a lie, they're gonna say you're not credible, you're not eligible, whatever case may be. If you enter the United States through the southwest border from May 11, 2023 to May 11, 2025, you have a circumvention of lawful pathway bar, which means that you're not eligible for asylum unless you qualify for an exception. There are a list of exceptions. Make sure you speak to an attorney about that, but that might come up in a hearing. So there are many different things that may come up in a hearing, which is why I would always suggest you get an attorney, because they can streamline this process and make it very easy. Your attorney will tell you everything you need, what day and time you need to be there, and they will prepare you for those hearings. At the end of the hearing, judges will generally allow your attorney to make closing arguments. So your lawyer will argue, Judge, we request that you grant my client's application for asylum. He was persecuted because of his religion. He was beat. The police wouldn't get involved. He had to leave, whatever case may be. At that point, the government's attorney will probably oppose, because at this point, they're opposing everything. And then the judge will issue a decision. It'll be either written or orally, and they'll lay out why they are granting or denying your case. If you get a grant, great. In today's society, in today's Trump's administration, if you get a grant, DHS automatically will reserve appeal. That means that they believe the judge made an incorrect decision granting your application, and they want to take it to the Board of Immigration Appeals. We call that the BIA. They have 30 days to file that appeal. So that means that the judge's decision is not final. So yes, you may have a grant, but it's not final because the DHS attorney might file an appeal. However, if they don't file an appeal, the decision is final and you can file for your green card. Once you get that, and then if you have relatives in your native country, you want to send them over, you can file an I-730 for them to come over if you get an approved asylum application. If your application is denied, the judge will tell you why your application was denied. I didn't believe you were credible. You didn't meet the 1-year mark. You were not eligible for asylum because of the CLP. You We're a separate past persecution, but things in your country have changed, so there's nowhere for you to be. You shouldn't be scared anymore, or the police can help you, or you could relocate. For whatever reason, the application was denied. Your attorney should reserve the right to appeal. You'll have 30 days to appeal. The appeal process used to cost $110. Now it costs $1,000, $1,045. You have 30 days to file your appeal with the Board of Immigration Appeals, and then you'll let the BIA know why the judge was wrong for denying your case. And this also goes for green card applications, 42B, cancellation removal, or 42A if you have a green card and they're putting you in removal proceedings, whatever relief you're seeking. Okay, so this is just about decisions and appeals. We just went over that. This goes into rights that you guys have as non-citizens in immigration courts. Right to legal representation. You do have the right to an attorney, however, it's at no expense to the government. So you have to be responsible. There are attorneys that do this type of work for free. There are legal aid societies. That means that they do it for free or they do it for a reduced price. And then immigration attorneys like me. You have the right to a fair hearing. Now, things are kind of changing. The Trump administration is trying to make it extremely hard for non-citizens to have a right to a fair hearing. There are a lot of constitutional violations that are being brought. So if you are entitled to a hearing, however, if you don't get the hearing, there are ways around it that we can make constitutional arguments to get you a hearing before they take away your green card or order you removed. And then you have the right to appeal, which we already discussed. All right, so these are the consequences of removal orders. If you were ordered removed, these can have severe consequences to you as well as your family members. It can lead to stress, social dislocation, economic challenges for family members, and the repercussions can extend beyond the individual, affect the family dynamics and community structures. As you guys have known, ICE has been detaining everybody. We have seen a lot of people getting ordered removed for things that they wouldn't have been detained for last year. So it's very important that if you are placed in removal proceedings, you hire an attorney or somebody that can represent you to make sure that you are not ordered removed. These are just recent trends and changes in immigration policies from the Obama era. DACA, this is if you were brought to the United States as a child from a certain time period, you may be eligible for DACA, which could lead to you getting work authorization. There was a slowdown on it with the Trump administration. However, as recent as last month, the USCIS is now taking DACA applications unless you live in the state of Texas, which unfortunately you guys are in Texas. So it is a little different with DACA for Texas residents, but you should still seek local counsel because they may be able to assist you if you or someone you know is eligible for DACA. All right, we're just gonna skim past DACA because that's not really here. All right, this just goes over case studies of immigration. If you have a criminal record and you are in immigration court, you must speak to counsel to go over what you're eligible for and your possible relief. If you are arrested and you have criminal cases pending, before you take any plea deal, please let your immigration attorney know that you either are a green card holder, you have overstayed your visa, you came to the border without inspection, whatever your immigration status is, you must let your immigration attorney know because, not the immigration, excuse me. Well, if you have an immigration attorney, let the immigration attorney know that, you were arrested. But if you have a criminal defense attorney, let them know, hey, I do not have status. I'm a visa overstay. I have a green card application pending. I'm a green card holder. I'm not a citizen. Whatever your status is, let your criminal defense attorney know and let them know that they have to speak to an immigration attorney if they are not familiar with immigration law. The reason is you might plead to something that your attorney might think, oh, it's a misdemeanor. You're only going to go to jail for a year and some change, or you're only going to go to jail for less than a year. Whatever case may be, it's not a big deal. It may be a great plea deal for your criminal attorney, but because you don't have status or you are a green card holder or whatever your immigration status may be, this can have severe impacts on your immigration application. So let's say you got arrested for a DUI. You have 2 DUI convictions. Your attorney was able to get them knocked down. Great. You don't have to go to jail for a long time, but this can bar you from getting asylum. So that's why it depends on what you are convicted of matters in your immigration court proceedings. So it's very important that you let your attorney know. I can't even begin to tell you how many criminal attorneys I've spoken to for my clients that they tell me, I didn't know your client wasn't a citizen, or I didn't know the immigration status, so they took a plea deal, which I thought was great at the time, but now you're telling me that they can't get their green card, or they can't get whatever application they need. Perfect example, 42B, cancellation of removal. One of the requirements is that you are a person of good moral character. If you have a long criminal rap sheet, it's going to be hard to prove that you're a person of good moral character. So, like I said, criminal case matters a lot. Child custody case matters. If you are seeking a green card or citizenship in the United States, but you are behind on child support payments and your child's parent lets the government know that, you'll have some serious issues. So that's important. You should let your attorney know, hey, I have a child. While me and the child's parent doesn't want to communicate, I talk to my child. However, I am behind on child support payments. We don't have a good relationship, whatever the case may be. You need to let your attorney know that so that we can figure out what we can do moving forward. If you are behind on taxes, that's something important that we need to know. That goes towards good moral character. You've been here for 10 years, but you haven't paid your taxes. You're trying to seek asylum, but you're behind on taxes. You lied on your taxes. Whatever the issue is, let your immigration attorney know so that we can figure out the best game plan action for your specific case, because immigration is not a one-size-fits-all. So it's very important to know. What may have worked for your friend or your uncle or your sister may not work for you. So while your best friend's attorney said, oh, well, you were arrested for DUI, your best friend's attorney did this for you, so it should work for me, that's not always the case. Every case is different. So that's why you seek counsel, so that we can go over a specialized game plan that is specific to your case. And I also want to let you know, as an attorney, I'm your lawyer. I want you to be honest with me. If you've done something, you submitted a fraudulent document, if you were once in a fraudulent marriage, I don't care, whatever it is, whatever your case may be, I need to know, or your attorney needs to know, so that we can figure out what the best option is for you. What I dislike most is when we go in front of a judge or we go in front of a USCIS officer and they're telling me things that I had no idea about. And it's like, whatever it is, we can get ahead of it, but I can't get ahead of it if I don't know. Trust me, I've seen it all. I'm here to help. All right. Let's see. This just goes over emotional tolls, criminal records, asylum seeker rights. All right, resources for legal assistance and support. Like I said, there's legal aid. If you don't have the finances to afford an immigration attorney, there are a lot of legal aid societies in your area that would be able to help you. If you have any questions about that, I can probably refer you to a few. I don't practice in Texas, but I know of certain charities that are available all over the country, so we can point you in that direction. They have local nonprofit organizations, government assistance programs. They're online resources, as well as community workshops and seminars, which is similar to what we are in right now. All right. So removal proceedings can be challenging. They can be complex, stressful, painful, difficult, expensive, and it can cause extreme impact on you and your family. Understanding the nuances of these proceedings are very important for navigating the immigration system effectively and ensuring that your rights are protected. Excuse me. Like I said before, I always suggest that you can speak to an experienced attorney on your case, because this will help streamline your process. You have no idea how many times I've had clients who've had a very simple case get messed up because they didn't speak to an attorney, or they submitted the wrong evidence, or they submitted the wrong evidence, or they didn't submit evidence. And it was something that was so simple that an attorney would have been able to catch, but because they didn't have an attorney, they missed it, and now it ends up costing them way more money. Speaking of attorneys, if you can't afford a certain price, a lot of attorneys are willing to work with you and lower their price, or refer you to other counsel that you may be able to afford. This, experience can be complex and difficult, but it doesn't have to be. So, we are a community. We are here as immigration attorneys. We're here to help you, assist you, and even if we can't assist you, we can probably put you in the right direction of somebody that can assist you. Okay, so with that said, we are, I believe we are done with our presentation. And, I'll just leave this key takeaways and recommendations. As I mentioned before, an attorney, a lot of attorneys do free consultations. I do free consultations. During a consultation, you can let your attorney know, or the attorney that you may hire, I don't know if you're gonna hire them, you can let them know what your case is about, give them the facts of the case, that they can let you know whether or not they can help you, what you can do, etc. Know your legal rights. This is very important, especially with ICE. You want to be careful about what you tell the government, because while the government is there to help streamline your process, they don't represent you. So you want to be careful about what you're saying to the government. If ICE comes to you and they ask you for your status, do not lie. Please do not tell the government that you are a U.S. citizen if you are not a U.S. citizen, because this can prevent you from ever having any type of immigration benefit in the United States. Community support is vital. As I just mentioned, you have a community. We here are a community to help assist you. You have Nigerians in West Texas, great organization that helps point you in the direction of whatever you may need. So if you need anything, feel free to reach out to them. They're here to help. Please stay informed on policies. Things are always changing in the immigration policies. As you know, Trump is working very hard to take away rights for non-citizens. So it's very important that you stay up to date. Something that you may have been eligible for last year, you may not be eligible for anymore. Something that you may have not been eligible for last year, like DACA, you may be eligible for now. So make sure you stay up to date and inform the policies. Like I mentioned before, prior, getting dismissal in court was great because then you won't have a removal order and you can get outside relief. Now, getting dismissal may end you up in a nice detention center. So very important to stay informed on policies, and then engage with advocacy groups. There are a million advocacy groups. ALA is one of them. Catholic Charities is another one. So there are a lot of advocacy groups. We're all here to help you. We are a community, like I say. I'm very pro-migrant. I am here to assist any way I can. And that's why we do the things that we do here. So that is my presentation. I will stop sharing my screen. Let me click out. Okay. All right. And now is a chance for questions. I don't know how you want to moderate this. If you want me to just take questions or you want to put questions in the chat, I'm here to help.
Yes, ma'am. We are going to be posting the questions in the chat. But the first thing we want you to do for us is we want you to answer this question for us.
Sure.
How much do you charge for consultation fees, and how do we get hold of you?
Okay, so my consultation fees are free. I offer free 30-minute consultations. So if you would like to consult with me, I can I have an Instagram and I have a website. I can submit that information to you right now. Let me get my
Yes, please go ahead and post it in the chat.
Sure. And then there is a link box where you can schedule a consultation. You can reach out for a consultation. You can schedule one for you. And then I am located in New York. However, I can represent anybody all over the United States, and we could do virtual conversation. We can do a virtual consultation. But my consultation is 30 minutes for.
Okay, right. Awesome. Thank you. Thank you so much for that. Thank you so much for that. Because who does not like anything that is free, especially when it's 30 minutes. So Absolutely. We're going to go ahead. We're going to go ahead and be posting the questions in the chat, and everyone can do so. The first question has just landed in the chat.
Can someone under removal proceedings still apply for a work permit or other immigration benefits? Absolutely. So if you are in removal proceedings and you have an application for asylum pending, you can apply for work permits. It used to be free, but now your work authorization card is $550 for your initial application. Same thing with 42B, cancellation of removal. Same thing for any other relief that you're seeking in immigration court. However, if you have a removal order, you can't apply for certain immigration benefits. But yes, if you are in immigration proceedings, you can still apply for other relief. Yes, depending on what the relief is.
Thank you so much. The second question is
how can families prepare if a loved one suddenly receives a notice to appear? So this depends on whether that client is detained or not. Regardless of whether the client is detained or not, the first thing you need to do is consult with an attorney. Give your attorney a copy of the NTA and let them know, hey, I was issued an NTA. What does this mean for me? The attorney will let you know, okay, you have to go to a master hearing. This is why you were placed NTA. A lot of people that have been having immigration, let's say you applied for I-130, I-45, they denied it, they issued you an NTA. If that's the case, speak to your attorney, they can help you figure that out. If you had an asylum interview, it didn't go well, they issued you an NTA, speak to an attorney, they can help you out. So the first thing you can do to prepare is speak to an experienced immigration attorney, and they can go over a game plan for what you're eligible for, what you could do, and why you were placed in immigration court. All right, I see another question. As an American citizen, what options do you have if you were to be arrested by ICE during the Trump administration? Great question. If you are an American citizen, don't try to fight the arrest. If ICE comes in there and they're trying to detain you, you got to know, hey, I'm a citizen. I have proof of my citizenship. I have a passport. I have a birth certificate. Whatever proof that you have, you can provide that to them. If they don't care and they still detain you, that's fine. Don't resist arrest because it makes it worse. Just get arrested. Once you get there, you can sort that out. You can get released. There have been lawsuits being filed on behalf of U.S. citizens that have been detained by ICE. So you could also look into that as an option. Reach out to an attorney. They'd be able to assist you further on. Another question. Assuming I initially gave a reason for my asylum application, can I change that reason if it's not strong enough? So yes, if you file an application for asylum, and let's say you have multiple claims for asylum, you have a religious claim, you have a domestic violence claim, you have a political claim, whatever. Some applications can be intertwined. You are allowed to amend your application and change it. However, I just want to put this out as a disclaimer. If you change your asylum application case, the government is going to use that against you. Why didn't you tell us this when you first came here? They're going to, now that you've learned that this claim is no longer viable, now you have a new claim. So they're going to use that against you. Speak to an attorney. There are ways around it. You can also argue change circumstances. So let's say you came to the U.S. because you had religious asylum, and then while you were here, you transitioned and you became gay, whatever the case may be. Now you've changed circumstance. You want to change your asylum application. So yes, you are allowed to change your application. Depends on the fact of the case. Just know that the government can and will use it against you. Any other questions? And these are really good questions, guys. I'm loving them. All right. What are the most common defense strategies that help people avoid deportation? Okay. Having an application pending. If you are detained by ICE and you have no application pending, there's no reason to keep you here. That is the quickest way you will get deported. Another thing that you can do is show that you have good moral character, you have U.S. citizens here. So let's say you were detained, you don't have application pending, but you have a 21-year-old child that's a U.S. citizen, they're going to file for you. Make sure you let the court know that, hey, I don't have anything pending now, but my child is going to file for me. I'm eligible, whatever. But the most common defense application that you can use, strategy to use to avoid deportation, is to have relief pending. If you have no relief pending, or if you don't have relief that you're eligible for, it almost makes it impossible to stay here without any kind of relief or status. Any other questions? All right. Are there any protections for immigrants married to U.S. citizens with U.S.-born children? Absolutely. So if you are married to a U.S. citizen and you have U.S.-born children, they can file on your behalf. If you came here through the border, you would have to go back to your country for consular processing. You would have to get a waiver. That's a different process. We can discuss that if anybody here is possibly eligible for that. If you came in on a visa, or if you came into the CBP1 app, you can adjust your status here. Your U.S. citizen child, if they're over the age of 21, can file for you an I-130. Your partner, if they're a U.S. citizen or green card holder, can file an I-130 on your behalf as well. And you can file your I-130 and your green card application concurrently, which means you can file it together. You don't have to wait for one to be approved, unless, this is a disclaimer, unless you came in through the border illegally, or if you came in without a visa or something like that. All right, what mistakes do people commonly make that weaken their case? Okay, no evidence. If you have a green card application based on marriage and you don't submit any evidence that you're in a legitimate marriage, that's gonna make your case weak. It doesn't matter that you've been married for 5 years or that you're in a legitimate marriage and you guys are really in love. We need evidence. The government needs to see joint bank statements, joint taxes, a joint lease, joint bills, so utility bills. They want to see photos, you on vacations. They want to see you with your wife and her family. They want to see you at your brother-in-law's wedding. They want to see all of those things, life insurance policies, car insurance policies. All of those things are very important. And even with bank statements, you can submit joint bank accounts, but they want to see the transactions. Are you using this bank account to pay for groceries, to pay for bills, to take joint trips? What did you guys do for Christmas? What did you guys do for Valentine's Day? They want evidence of that. So without submitting evidence, that will extremely weaken your case. I've seen so many clients that are legitimate marriages that don't submit real evidence to USCIS, application gets denied. Asylum, if you have a valid asylum claim, you need evidence of that asylum application. It may be hard for you to get evidence. If you can't find evidence, let your attorney know and let them know why you can't get that evidence so that we can tell the court, hey, my client was in a war. She ran out when her house was on fire. She was unable to grab evidence, but we have this, and that to show that this really happened, that she was there. So not having evidence will weaken a really good case, which is why I would suggest speak to an attorney. They can help you navigate this process. How important is it to have an attorney during removal proceedings, and what can happen if someone goes without? It is very crucial to have an attorney. I myself have not seen anyone be successful in immigration court without a lawyer. There may be people out there that have done it on their own. I personally haven't seen it. It's very important. You almost can't really do much without an attorney because you need to submit your evidence. A lot of people go to notarios because it's cheaper. However, notarios are not lawyers. So if they make a mistake on your case and you get order removed, there's no repercussion against that notario, and there's really no way you can get that case reopened. However, if you have an attorney and your lawyer makes a mistake in your case, you can hire a new attorney and do a motion to reopen based on incompetent representation of your past attorney. So having an attorney is very important. Does it cost more money? Yes. But sometimes when you don't have a lawyer and you do it yourself, or you hire an notario, you end up spending way more money to fix the mistakes that an attorney wouldn't have made. And if you have an attorney and they did make mistakes, you can get those mistakes cured by a new lawyer, because a new lawyer will say, hey, they had an attorney, the attorney messed up. If you don't have an attorney to do that, if you made a mistake on your own or an attorney made a mistake on your own, you don't have that argument to make. So to me, having an attorney is extremely important. Any other questions? All right. How does asylum or refugee status affect removal cases? So if you get your asylum case granted, that's great. You could apply for a green card almost immediately. Once DHS, if they reserve the right to appeal and they don't, you could seek a green card. Even if they reserve the right to appeal, you can seek a green card. And then if you have no criminal record or anything else during that green card period, you can get you a green card within a year. Any other questions? All right, I think that's everybody that had questions. Oh, here we go. Here's one. Can someone still be placed in removal proceedings even after living in the U.S. legally for years? Absolutely. If you have a green card and they found that you did marriage fraud, that you committed a serious felony or crime involving moral turpitude, whatever the case may be, they can revoke your green card and they will put you in removal proceedings. At that point, you need to file a 42A cancellation of removal proceedings. So having a green card does not give you permanent status. It's temporary until you become a citizen. So you can be placed in removal proceedings even if you have a green card. What can family members do when one member is detained by ICE? The first thing you do is you figure out their alien number and you go to ICEDetaineeLocator.com. You put in their alien number, you put in the country that they're from, and they will tell you where they are located. Once you find out where they are located, speak to an attorney. They may be eligible for bond. If they are eligible for bond, your attorney will take over. And they'll let you know whether or not they're not eligible for bond. If you want to talk to your family member, you can reach out to the detention center. However, those calls are monitored and recorded. So if you say something that you shouldn't say on the phone call, just know that it's recorded and the government can and will use it against you. So hire an attorney that help you navigate that. What are the safest ways to communicate or visit a detained loved one without putting others at risk? So reach out to the detention center. You can schedule a call, or the loved one could call you. Sorry, you can't schedule a call. I apologize. You can reach out to the detention center, and if you have an important message, they can reach out to the person for you. You can send mail to them. Just know that whatever mail you send to them, they may open it. The guards will open it and read it. So just be careful what you're sending in the mail. You can visit them in person. Just make sure you have no weapons on you. If you don't have status, you should not be going to visit anybody in the detention center because you yourself don't have status. So if you want to visit a loved one and you are here with no green card or you have no application pending, you don't work or anything, I would not suggest you go to the detention center because you may also be at risk for being detained. How can communities like NIWT help prevent misinformation about deportation or ICE raids? The best way to prevent misinformation is to make sure that the information that you are giving out has been vetted. You can get your information vetted by speaking to an experienced immigration attorney to make sure that you are giving your community the most recent and updated policies to help them avoid making common mistakes. Any other questions? How important is it to have legal power of attorney or emergency plan for children if parents are detained? It is extremely important. If your parents are detained, they won't have access to their bank accounts, and that might be the money that you need to hire an attorney. So if you are a parent and you don't have status and your children are of age where they can control your finances, you should get them power of attorney, get that notarized, and give it to your banks beforehand to say, hey, I don't have status or whatever it may be, but in the event I get detained, my child is my power of attorney and they have the right to take out funds on my behalf or make any changes they need to make on behalf. That's a really good question to know, because I get that a lot. Or I have clients who take trips and they kick it back into the country and now they have issues with power of attorney.
Wow, you've spoke and you've really answered a lot of our questions. We really don't want to hold you hostage. We know it is weekend, and I know New York is like an hour ahead of us. So thank you so much, Attorney Jackson. You've really done a lot. But there was something you shared the other time that you said you would be able to send us resources about some legal aid or legal free legal opportunities that people can explore in this area. If you don't mind, I will also stay in touch with you so that you can please send those to us. Do you have any final advice that you want to give to everyone?
Yes. My final advice would be that you want to make sure that whatever you are doing, you are properly guided. And the best way to do that is with an experienced attorney. If you do not have status, that is perfectly fine. You may be eligible for relief that you didn't know. If you are to be encountered by ICE, you don't want to resist. You do have rights. So you want to be careful what you tell them. Do not lie about your name. Do not lie about your status, because that could cause you further problems ahead of time. You don't have to be fully upcoming. You don't have to tell them everything, you know, but you do want to be careful about what you are letting the government know. If you're stopped by ICE, like I said, and they ask for your ID, you want to first make sure that they are who they say they are. Don't just hop in anybody's car. You have the right to ask them, I want to see ID. I want to see proper verification. How do I know that you're really ICE? Is there a way that I could just turn myself in at the detention center because I don't trust to go with you? You want to make sure that, you know, you're not just giving yourself up to anybody, because there have been cases of people portraying to be ICE officers and they're not. Please don't lie about your status. Do not tell ICE officers that you're a citizen if you're not a citizen, because it makes it almost impossible to get relief later down the line. If you have any questions, I'm also available to help. Like I said, I offer free 30-minute consultations. I put my website in the chat. Nigerians in West Texas is a great organization. They have a lot of resources. They have been doing a great, amazing job with the community in West Texas to make sure that you guys have the best information, or the most up-to-date information that you guys need. So they're also a great organization to reach out. But yeah, hiring an attorney can really help save you in the long run if you don't know what to do. I know you might have relatives that have been through the process and try to give you guidance, but they're not a lawyer and they're not an immigration attorney. They may not be the best ones, because things have changed drastically, and what may have worked for them may not work for you.
Already, thank you so much. We can only hope that next time, if we have the opportunity, you will also be available to make another presentation for us. We are really been blessed to have you around. Thank you so much, and you have a nice weekend ahead of you. Thank you so much.
No problem. Everybody enjoy the rest of your weekend. Thank you for having me. I appreciate it. I love doing this type of work, and I'm here to help. So hopefully, you know, you guys, I wish you all the best in your luck or whatever immigration relief you're seeking. And if you need anything, you have my information. So please do not hesitate to reach out.
Thank you so much. You have a nice day, man. Thank you.
You too. Mommy.